From January 1975 through May 31st, 2009, there have been a total of 213,814 crossing accidents, which were reported by the railroads to the National Response Center. Closer examination reveals that over 20,000 people were killed in these accidents and another 79,469 people were injured. Shocking statistics were recently reported by the Federal Railroad Administration regarding railroad-related accidents and injuries. It is estimated that cars and trains collide every 12 minutes, with a total of 9,570 train incidents and accidents in the year 2009. Here are some disturbing statistics. Of the 9,570 train wrecks, 649 people were killed and 6,686 people were injured. The average train weighs 12 million pounds, so the weight ratio of a train to a car is about 4,000 to 1. This compares to the weight ratio of a car to an aluminum can. A train traveling at 50 miles per hour, pulling 100 cars, takes 1 mile to stop. So in a contest between a car and a train, the train obviously and always wins. The motorist in a train motor vehicle collision is 40 times more likely to die than in a collision between two motor vehicles. This fact is a real shocker. As of December 2009, the United States had 136,041 public at-grade railroad crossings. Of these crossings, approximately 42,301 have gates, 22,039 have flashing lights, and 1,196 have highway traffic signals, wigwags, and bells. So do the math. The remaining railroad crossings, approximately 72,000 in America today, over 50% have nothing. No warning lights, no gates, and nothing to protect drivers. Plus, to make matters even worse, not only are these 72,000 crossings unprotected, many of them are overgrown with weeds, trees, and types of vegetation, making the crossings very dangerous, like you cannot see the train a-comin'. On November 6, 1998, a Union Pacific train struck Frank Stevenson's red Nissan Pulsar as it crossed the tracks on Highway 364 in Vandale, Arkansas. As a result of the collision, Frank suffered severe injuries, has no memory of the accident, and his loving wife of many years was killed. Frank Stevenson had lived 300 feet from the Union Pacific Railroad crossing for over 15 years before this accident. Today, the Insider exclusive goes behind the headlines in this TV exclusive, Death on the Tracks, Union Pacific's Deadly Cover-Up, to show how Robert Potroff, partner at the Potroff Law Offices, and his team of lawyers successfully uncovered, as the court wrote, a pervasive and sinister corporate policy at Union Pacific that put company profits before public safety. And the court continued, Union Pacific intentionally destroyed track records and voice tapes. Furthermore, there is evidence from which a jury would reasonably conclude that Union Pacific attempted to conceal slow orders issued for this portion of track. The biggest challenge in this case facing Bob and his lawyers was establishing how somebody could have ever been hit by a train at such a familiar railroad crossing. This challenge was compounded by an absence of witnesses to the accident, missing evidence, and federal preemption of the strongest claims against the railroad. Railroad photographs taken by Union Pacific of camera angles the day of the accident made it appear that the view in both directions was wide open. But that simply was not true. Bob illustrated how the wrong camera height allowed the railroad to conceal view obstructions with misleading photos. Unbelievably, relevant records that predated the accident were destroyed after the accident, and voice recordings of the crew and railroad dispatcher were also destroyed. A pattern of discovery abuse was ultimately established. In a published opinion, federal court judge Bill Wilson stated that he was disturbed by the lack of communication and cooperation within defendants' organization, and that the railroad, in essence, contends that its right hand often knows not what its left hand is doing, and remained willfully blind and uninformed, intending to rely on its document retention policies to avoid discovery. In addition, the railroad was ordered to pay $164,410.25 in attorney's fees and costs for discovery abuse. Union Pacific's record of 7 court sanctions between July 2001 and January 2003 for destroying or failing to preserve evidence is outrageous. In fact, Union Pacific's own claims manual served as its own smoking gun, as it states verbatim, in more serious cases when company liability is obvious and no mitigating circumstances develop, no useful purpose is served by extensively documenting evidence. Bob Potroff has earned the highest respect from citizens and lawyers alike as one of the best train accident lawyers in the nation, fighting for the victims of railroad companies in the battle for railroad safety. And because of that, he is driven to fight for people who have been harmed by the willful or negligent actions of others. His goals, not only to get justice for his clients, but to make sure that all railroad companies implement maximum safety protections that all Americans need and deserve. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from Minneapolis, Minnesota, with the Potroff Law Offices. It is my great pleasure to introduce Bob Potroff and Steve Boyd to the show. Welcome, guys. How are you?
Good to see you.
Tell us a little bit about your firm, which is based in Manhattan, Kansas. What do you primarily do?
Well, for the last couple decades, it's been almost exclusively railroad litigation. We represent members of the public who, for some reason or another, have gotten sideways with the railroads, either public safety issues, property issues, but we've always represented those members of the public who have problems with the railroad industry in the public sector.
And problems meaning that a lot of people end up getting killed at railroad crossings for a variety of different reasons we're going to get into in a minute. Railroads, for our viewers' knowledge, have great law firms that represent them. And generally their posture is they blame the person that got killed for whatever, correct?
Corporate policy.
Yeah, and your philosophy is there's a lot of railroad crossings that are not protected, that are unsafe, and you really have to look into a case to see whose fault it was, correct?
Absolutely. In fact, the industry knows that they've got proven safety devices that will prevent about 95% of these accidents.
Yeah.
And rather than embrace the safety devices and try to maximize their use, they would rather blame the driver, blame the pedestrian, blame the public, and defend the cases.
Yeah, and that's important, and the reason we're doing these shows is there are very few really good train lawyers, if you will, in the country that represent individuals. And these cases cost a lot of money to put on, don't they? And they take a long time, and the other side, as we will see in this case, or we're going to discuss the Stevenson case, really throw a lot of crap against the wall that is kind of unbelievable to the normal layman, right?
These cases, if you aren't well financed and ready for a long battle, they're not for the faint of heart.
Yeah. Now, Steve, you could practice any kind of law. I mean, you could represent major corporations, but you choose, and so do you, Bob, but you choose to represent the little guy. Why is that?
It's always been my nature to represent those who need representation the worst. Usually it's the small guy who doesn't have that ability to hire a major law firm. So when cases come in of this nature, I have found, working with Bob over the last 10, 15 years, that we can do a lot of good. Mm-hmm. We can not only bring compensation and restitution to those who have been wronged because of negligence by an industry, but there's a sense of self-satisfaction that we serve the human need of safety.
And you feel the same way, right, Bob?
It's a unique opportunity to, the freedoms, the ability in our civil justice system to actually stand up for the individual, the little guy.
Yeah.
We like to say in our office, our clients bleed. We don't represent corporations, government entities, insurance companies. Our clients are real people with real issues against what appear to be overwhelming odds when they come.
Yeah, and we're going to discuss what happened in the Search of the Truth in the case that we have at hand here right now, which is Stevenson versus the Union Pacific Railroad. Tell us, Bob, a little bit about the facts of what happened.
An interesting case. We have Frank Stevenson and his wife, Mary. He's going to take her to town. She has to go in for some physical therapy. The challenge of this case is that the crossing where they're hit at is right by their house. So they know it's an active railroad crossing. It's got some vegetation problems. It's got a...
And when we talk about vegetation problems, really define that. The railroad hasn't cut the grass, right?
The high grass that had grown up made it just high enough that it could obscure the view of a train, but not so obvious that made you stand up and shout, "Oh my goodness, this is a visual obstruction."
Yes.
You kind of had to be in a specific place at a specific time to recognize that it was an obstruction. It had a crossing that had been allowed to fall into disrepair enough that if you were familiar with the crossing, it would be a distraction to you because you wouldn't want to run over that part of the crossing that could damage your car. And the other part of it that familiarity actually worked against Frank and his wife was they lived next to the crossing, so they're used to hearing these train horns. And you hear the horn, you associate train. You hear the horn, you associate train. On this instance, not hearing a horn, just subconsciously you associate no train, and because of the lack of a horn, the visibility obstruction, and the rough crossing, it was the perfect formula for a trap for a very cautious driver.
What happened to them?
As they pulled out of their driveway, tried to make it across that crossing, it took just a few seconds for this train to come from behind the vegetation, finally sounded the horn when they were on the crossing with no escape, T-boned the side of their car, killing his wife and brain injuring Frank.
Now, your firm, in pursuing this case, prepares some really detailed, extensive animation. One of the things that I want to show on the screen right now is there was the issue of obstruction, where the train, Union Pacific, actually, their employees went out and they took photographs of what they considered an unobstructed view. And the interesting thing is, we'll see on the screen, is I believe that their view was 68 inches off the ground, correct?
Correct.
When everyone knows nobody drives a car standing up, correct? Standing to the roof of your car. So you created this comparison, which we're showing on the screen right now, where it's shown from the driver's point of view, which was 39 inches, about 30 inches less, correct? I mean, these are some of the tricks that Union Pacific tried to fool the jury with, because otherwise they wouldn't know, right?
One of the things that was very satisfying about the Stevenson case is that we got, for the first time, production of the claims manual that they train their investigators with.
Yeah.
And actually in that manual, it suggests that if you have a visibility obstruction, you may be able to move your camera just a little bit one direction or another to avoid the obstruction, and that's where you should take the photos from. So what they did in this case is, rather than take the photos from eye height of the driver, they got up above the vegetation and took this entire sequence of photographs that made it appear you could see miles each direction. Terribly misleading.
They intended to deceive.
No question about it.
And it's your job is to search for the truth and find out exactly. Now, in using your legal strategy, okay, what did you have to prove to the jury initially?
Well, the first thing you have to prove is that Frank Stevenson, as he was driving that car, was doing exactly what they would do. You have to overcome this presumption that, oh my goodness, I would never get hit by a train.
Because everybody sees a train.
Because they're big,
Yeah.
they're loud,
Yeah.
they drive on the tracks, they don't swerve, they can't stop. And we had to take the position that that's exactly what Frank believed. That was his thought process. So in essence, we wanted the jury to, if you will, get in the front seat with Frank and watch how he drove.
Yeah, in other words, say, why would a person who lives across from a railroad crossing, knows the dangers of driving on a track when a train's coming, why would he do this? That would be suicidal if he did it intentionally, right?
Absolutely.
So obviously, he didn't hear it and he didn't see it. And the real question comes down to why, right?
And that is the million-dollar question. The railroads would just as soon you never got to that question because they want to go on the prejudices they've created with their public relations that we're only killing people at crossings who are risk takers, and which was nothing further than the truth with Frank Stevenson driving his wife who couldn't go over that bumpy crossing very fast because of her medical condition.
Yeah, now you ended up getting a verdict of what, $2 million in this case?
We did.
But there was another issue, there was another award, if you will, sanctions. Tell our audience what that means and why was it awarded?
We picked, I don't know why it was in the Stevenson case. We had several cases that the railroads had engaged in similar activities where they hid evidence, destroyed evidence, and we kind of drew the line in the sand in the federal court case with Judge Wilson. He was known for strong rulings and a willingness to support a litigant's right to the truth. So we started attacking very hard areas where they had been destroying evidence. The voice tapes where the train crew reported the accident. They suggested they didn't know that those were important. This judge didn't take their excuses, required him to turn over other tapes, found they were relevant, but once destroyed, that he was going to instruct the jury about that. Their track inspection records that should have shown that they knew about the problems with this crossing surface and how dangerous it was were also destroyed. Records about complaints, any number of records that were just not there for us. This judge had enough.
Let me ask you this. These are cases that involve many people at Union Pacific. Do you think that the CEO and the chairman knows exactly what's going on and what some of the people within their organization are doing, destroying evidence? Do you think so?
It would be hard for me to believe that this kind of information doesn't go to the top.
Now,
in the case, one of these cases, Bob actually interviewed the guy who was in charge of preservation of the data event recorder and the voice tapes. And that director of information, Bob asked him, did you follow Judge Wilson's order to preserve these documents so they're available for court? And he said, well, no, I don't think we've done that yet. And Bob said, but you're the director. How come it hasn't been done? He said, well, that has to be made up above my pay grade. So it's hard for me to believe that they don't know that there's a deliberate attempt to.
And by the way, you brought up earlier that they had a claims manual, which we're showing right now. It says even in the most serious cases, when company liability is obvious and no mitigating circumstances develop, no useful purpose is served by extensively documenting evidence.
There couldn't be a much more clear indication of what the corporate line is. The tragedy is, in minor accidents or near misses, there's a potential for learning experiences that we know this is a dangerous condition. Fortunately, no one got killed. Let's document it, let's fix it, let's learn. That's what system safety is all about. And instead of trying to protect the public and their own employees, the election is don't document it, let's ignore it, let's pretend like it didn't happen.
And let's just disregard what a judge orders you to do, right?
That's correct.
And not just one judge. When we're talking about corporate knowledge, it'd be different if California and Arkansas and Arizona and Minnesota were different. this railroad has tracks all over the western United States, and I've found consistently throughout the United States the same issues with missing evidence, key evidence in investigations controlled by the railroad.
Corporate policy. There's 136,000 railroad crossings in the United States, and over half of them are unprotected, have no gates, have no signals, nothing. There's, I think, 9,000 accidents rather, that happen every single year, and thousands of people die. This is an ongoing problem. If you win one case, they continue the same conduct some other place. If a person has a railroad accident, do they need a lawyer to pursue their case?
There's no question. If there's going to be a case that is worth pursuing, you're going to need a lawyer that is well versed in railroad law and willing to put up with a very long, drawn-out fight.
I want to thank both of you for sharing this on the program. I know America is really going to pay attention to railroad crossings, and thank you very much for being on the program.
Thank you, sir.
Appreciate it.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.